In this video we are going to discuss Palakya Narain Swamy versus the Emperor. Air 1939 PC 47. This is an appeal case, and this case is generally read for understanding dying declaration and admissibility of evidence under Section 162 of CrPC. Facts. The accused's wife had taken some money from the deceased a year ago in 1936. On March 20, 1937, the deceased received a letter inviting him to come to Beer Hamper for collecting his dues, but the letter was unsigned. There was a general suspicion that the letter was sent by the accused's wife, but the judge was not satisfied with the handwriting evidence that was given. The deceased set for Beer Hamper, but he never came back. His body was found on March 23, 1937 from a passenger train in Puri in an unclaimed trunk in 7 pieces. The post-mortem report confirmed that it's murder. During the investigation it was found that the trunk was bought on behalf of the accused. Evidence was given by the washerman of the accused who bought it on behalf of the accused, and also by the shopkeeper who sold the trunk. Issues. A number of questions arose in this case. Whether the statement of the deceased's wife that the deceased told him that he was going to collect his dues from the accused's wife will be treated as a dying declaration or not. Whether the statements given by the accuseds during the investigation will be protected under Section 162 of CrPC or not. Judgment. The judgment was given by a 5-judge bench of the Privy Council, and it was delivered by Justice Atkin. Regarding first issue, the judges said that the statement may be made before the cause of death has arisen or even before the deceased had any reason to anticipate getting killed, but the circumstances must be circumstances of the transaction, and any general expression of suspicion or fear from any individual or otherwise that is not directly related to the case will not be admissible, which means that the circumstances must have some proximate relation with the actual occurrence. Therefore, the statement was said to be rightly admitted. Regarding second issue. Reasoning. In this case, the Lordships gave a detailed reasoning with regard to the decision on the second issue. 1. The Lordships reasoned that in Section 162 of CrPC the mention of the words any person would mean each and every person giving their statement. During an investigation many people are suspected to be the accused, and all of them may have to give their statements. The fact that the section prohibits the signing of the recorded statements should essentially mean that the section should be applicable to the accused person also. 2. It was also stated that if the intention of the legislature was otherwise, or if there meant to be an exception, then it can be safely expected that it would be expressed in the section. In this case the Lordships could not see any reason for departing from the plain meaning of the words used in the section. 3. Section 25 of the Evidence Act also supports the decision. Section 25 says that no confessions made to a police officer shall be proved against an accused person. In addition to this, reference to Sections 26 and 27 were also given. Therefore the appeal was dismissed by the Privy Council.